Thank you for watching this video. My name is Takashi Koike, and I am a member of the International Activity Center in JPAA. Today, I'm going to talk about good faith negotiation guidelines for standard essential patent licenses that were introduced by the Japanese government in March 2022. So why would you like to have the guidelines? As you are aware, we are in the middle of the fourth industrial revolution, and as part of the revolution, new technologies such as the Internet of Things and digital transformation bring us new values. However, because so many fields are now utilizing information technologies or communication technologies, the needs for standard essential patent licenses is expanding in various industries. And as a result, not only communication technology companies, but also other companies may need licenses from SEP holders. The problem here is that the different industries may have different cultures and ways of conducting negotiations, so the negotiation could be very complicated and unpredictable. Therefore, the guidelines were established to facilitate negotiations among different industries and to improve the predictability and transparency of SEP license negotiations. Then, what kind of issues should we address? Here is a list of typical issues in SEP licensing. 1. Who needs a license? Final product makers or suppliers? 2. How do you determine the license conditions or terms? Everyone knows that the conditions must be front, but what are front? 3. How to conduct a negotiation? As a SEP holder, what information do you need to provide to implementers? Or, as an implementer, what information do you need to provide to the SEP holder? 4. We do not have a global standard. Now let's briefly look at each issue. Here is an example of the first issue. Let's say we have an automaker whose cars need to implement a SEP. The SEP holder wants to have a license with the automaker, the final product maker, because he expects that he can get more money from the automaker than suppliers. However, we have a supplier, A or B, who is willing to have a SEP license with the SEP holder because they know that their products need to implement the SEP. And because the suppliers are requesting a license with the SEP holder, the automaker refuses to have a negotiation with the SEP holder, saying that we don't need to talk with you. You should go and talk with the suppliers, not us. The second issue is, how do you determine front conditions? Front says that the conditions must be reasonable. But what is reasonable? For example, a SEP holder may say that the license fees calculated based on EMV are reasonable. On the other hand, the implementer may argue that the license fees calculated based on SSPPU are reasonable. There is another question regarding the front conditions. Front says that the conditions must be non-discriminatory. For this, a SEP holder may say that to be non-discriminatory, the license fees should be decided based on the application of the technology. For example, if you want to implement the SEP patent for an automation technology, the license fee should be X. But if you want to implement the patent for a smart technology, the license fee should be Y. On the other hand, the implementer may argue that the license fee should be fixed for any applications because the technology itself is the same anyway. Now, this is about the third issue. How do you conduct a negotiation? For example, we have seen a SEP holder arguing that the implementer intentionally delayed this negotiation so that they could not reach an agreement, despite the SEP holder's attempt to comply with front commitments. Also, some SEP holders say that the implementer should sign the NDA first. On the other hand, an implementer argued that the negotiation was delayed because the SEP holder refused to provide the implementers with information sufficient to enable them to make a proper decision. Further, implementers may argue that the SEP holder should at least provide a claim chart or other information prior to signing an NDA. The last issue here is that there is no global standard for SEP licensing negotiations. Each country and each region is establishing its own standard. They may look similar at some aspects, but may be different in others. So given these issues, the guidelines were established through discussion with practitioners and experts from industries, including domestic and foreign companies, and experts from academia. And the guidelines describe what action could be recognized as good faith negotiation to help both SEP holder and implementers. As I will be explaining in the next few slides, the guideline divides the negotiation process into 4 steps. 1, offer. 2, expression of willingness. 3, proposal. And 4, counteroffer. If the parties fail to reach an agreement, then the parties can address the dispute in court or seek for settlement through alternative dispute resolution, such as mediation and arbitration. Now let me explain each step a little more detail. At step 1, the SEP holder makes an offer to the implementer that should include A, documents for identifying steps, and B, claim charts. Here, the documents for identifying steps should include a list of patent numbers, the names of the standards at issue, and the geographical scopes of patents. The claim charts should map the SEP claims to the standards and/or to the accused product. Here, the SEP holder can state that the documents provided at this stage should be protected by NDA, but such a statement is not necessary. At step 2, the implementer should express a willingness to obtain a license under front terms. Remember, when expressing his willingness, the implementer can still reserve his rights to challenge the essentiality, validity, or infringement of the subject patents. Also, the implementer can disclose the information provided by the SEP holder during the negotiation to the suppliers and to patent attorneys as needed. In response to the expression of willingness by the implementer, the SEP holder can present a written offer for the license on front terms. In the offer, the SEP holder should A, propose specific license terms, including the proposed royalty, and B, explain how the proposed royalty is calculated. In addition, the SEP holder should provide royalty rates determined by patent pools and court decisions, if applicable. The important point here is that the proposal should be sufficiently specified to allow the implementer to objectively understand that the terms are front. If the implementer does not agree with the offer, the implementer can propose a counteroffer to the SEP holder. The requirements of the counteroffer should be identical or similar to the SEP holder's offer in step 3. So this is the last slide of my presentation. The slides explain the nature of the guidelines as a summary. The Japanese government explained that the guidelines are norms of good faith negotiations. The guidelines give us suggestions and recommendations, but do not have the power to legally bind SEP holders or implementers. Of course, they do not guarantee future judicial rulings. The judges can overrule the guidelines. However, the guidelines are intended to summarize the issues based on the current court rulings, the judgments of authorities, and licensing practices. The guidelines have already been introduced to the Japanese Judicial Branch and Fair Trade Commission, so we are expecting that the judges would at least refer to the guidelines or consider the guidelines when they make decisions. Also, we are expecting that the guidelines will improve the predictability and transparency of the SEP license negotiations in Japan. Thank you very much for your attention. I hope you find yourself interested in my presentation, and my presentation would help your activities in Japan. If you have any question, please feel free to reach out to me. Thank you.